Hi, I am Tiffany Weber and I am a real estate attorney in Mooresville, North Carolina. And today I want to talk to you about some tips for a smooth closing. So a lot of these tips are going to be geared towards agents and how they can make the process move along better for their clients, but there will be helpful information for buyers and sellers as well. So even if you're not a real estate agent, that doesn't mean that you won't get something out of this. So let's get started with one of the first things that you can do to make sure your closing moves along in a smooth manner. And this happens well before the closing ever begins. So if you are a real estate agent and you're about to list property, then make sure everyone who needs to sign your listing agreement and agency documents does so. How can you be sure that it's everyone? Well, one thing is go to the tax listing, look at the deed, check any estate files if there has been, if maybe the owner has passed, and then find out if there's someone that has gotten married since they bought the property. So a lot of times we'll see someone buys the property as a single person and then gets married and then they don't have their spouse sign the listing agreement or the contract, or someone has passed away and the realtor or the real estate agent has only had the executor or one heir sign all of the documents, when really all of the heirs and their spouses and the executor need to sign the listing agreement and the agency documents and the contract. So the first thing you can do is make sure that everyone with an interest in the property signs all of the listing agreement documents, all of the contracts, etc. The next thing is any amendments to the contract, to the listing agreement, basically any amendments at all, make sure that they're discussed and written down and signed by all the parties. I don't know how many times we get to closing and we find out that there has been some agreement to change the sale price or to allow a seller concession, but the amendment was never formally completed and the document hasn't been signed, or a copy of the signed document hasn't been forwarded to the closing attorney. So that's an unnecessary hiccup that can be avoided just by planning. So if there's going to be any amendment to the contract, get it in writing, get it signed by everyone. This next part talks about all of the information you need to get from a seller in order to make sure everything moves along the way that it should. The first thing is get a copy of the deed to the property. That way you can get the correct legal names of the parties and the correct spelling, and also the correct legal description of the property. The next thing is ask for a copy of the old survey. So sometimes if the survey is not too old, then the buyer can use it for the benefit of their title insurance. So that can be a good marketing tool to say, hey, we've got a fairly recent survey. Your buyer may not need to obtain a new survey if it's satisfactory. So get a survey so you can figure out if there are any issues with easements or encroachments, or maybe there's a boundary line dispute that you could learn about and try to resolve with that survey. Next, have your seller give you a copy of their old title insurance policy from when they bought the property. So if they don't know what it is or they don't remember getting it, then ask them for a copy of their closing statement, because you'll see on the closing statement a line item for the title insurance policy and the company that issued it. So you can go straight to that company and say, may I please have a copy of the policy? So what you're looking at on that policy is for any encroachments or encumbrances or any exceptions from the policy that you may need to be aware of going forward during the listing. If your seller is in the process of getting divorced or is divorced, get a copy of the separation agreement, or at minimum the memorandum of separation or the divorce decree, because it is almost certainly going to be needed during the closing process. It's very helpful if you get it up front rather than trying to scramble for the parties to get copies of it at the very end of the process. When you get a listing, you should go ahead and have your seller start gathering all of the information for their existing loan. So that means the loan numbers, sometimes the loan number and the account number are different. So if that's the case, have them get both. They'll be required to sign an authorization for the closing attorney to get the payoff, so they should be ready for that. And that payoff authorization requires that the loan numbers be provided along with the seller's social security number sometimes, or the final 4 digits of the social, in order to get that. Now, on the topic of loan payoffs, one thing that you should find out is the approximate loan balance on the property, because if there's any chance that your sellers are going to be short at closing, maybe the combination of the loan payoff and any expenses they have to pay plus commissions might mean that they'll have to bring money to the table. So while that doesn't happen often, if there's any chance of that happening, you want to be prepared for that on the front end so that you can have that tough conversation with your sellers, rather than them getting to the closing table and the attorney saying you owe $6,000 because you didn't have enough money out of your proceeds to pay for all of these things. When you get a listing, also get a copy of the restrictions, because buyers should be asking for this as part of their review of the property and putting in an offer. So if you have the restrictions on hand, then you're not going to be scrambling at last minute requests. And other things that you should get, copies of easements, well agreements, road maintenance agreements. These things are going to come up during the closing process. It's much better to get ahead of those things. Also, you've got to disclose things like that you know about. So you've got, if you've got copies of those things, it's a lot easier to just get it out in the open, get it discussed early on in the process, then have the buyers find out during the title search that there's some road maintenance agreement that they're going to have to be subject to, and maybe they don't like it, and now there's an issue. If the property you're selling has a mobile home on it, then it is my advice in North Carolina to not list a mobile home without having a copy of the title or the title itself, or proof from the Department of Motor Vehicles that the title has been canceled. So there's also another document called a Declaration of Intent to affix mobile home to real property. That alone is not sufficient evidence that the title has been canceled. So if it's a mobile home, you're going to need something from the DMV showing that the title's been canceled, or you should be able to locate the physical title itself. Next, find out whether the seller has made any additions or improvements to the property, and if there were any permits required for those additions or improvements, then get a copy of the permits. It's always a good idea during this time to be discussing the standard closing costs that sellers pay. So the North Carolina standard offer to purchase itemizes a lot of those costs that sellers pay, even if they don't say the exact amounts. But there are things like deed stamps that you can figure out on your own. You can figure out prorations of taxes. You can ask the closing attorney what the seller's fees are. And then, of course, if you negotiate any improvements or concessions or repairs that are going to go on the closing statement, you'll know what those amounts are. But you should be preparing your seller to understand that they will have costs they'll have to pay as well. And you should advise the seller to talk to their CPA so that they can find out whether or not there will be any capital gains involved in the sale. So you don't want your sellers to be surprised, so have them asking their CPA up front or getting an appointment to talk to their CPA pretty soon. If you have a seller that is in bankruptcy, then you're going to need approval from the court for the property to be sold. And the seller's bankruptcy attorney is not the attorney that writes up that document or does not have the sole authority to grant that permission. It's the bankruptcy trustee. So that is a long process, and it is subject to the availability of the courts and the discretion of the courts. So that is something that you should be working on well in advance of the closing date. You should not expect that if you go under contract on January 1st that you will have all of that buttoned up by the end of the month. So if you've got a seller in bankruptcy, it's a good idea to start working on that process before you even go under contract. And you should also make sure that the buyer is prepared, that there is another party involved. You've got the court system that may impact the closing date. And another thing you should find out from the seller or the seller's HOA is whether there are any pending or anticipated special assessments on the property, because those will need to be communicated to the buyer. All right, next let's talk about contracts. So of course it's very important that you have the correct legal names of the parties on the contract. You also need it signed by everyone that has a legal interest in the property on the seller side, and then of course any buyers that are taking title to the property should sign the contract as well. It's a good idea to go ahead and have your buyers sign the contract the way that they want the deed to read, because that's the way that the lender is going to prepare all their documents and the way that the closing attorney is going to prepare the documents. So if the buyer wants their name to read a different way, say omitting the middle name or making sure that the middle name is definitely included, then make sure you prepare the contract and any amendments with the name shown how they want to take title. Make sure that you're filling in the right deed reference, the right tax parcel ID number. You can get all this information from the tax office or from the Register of Deeds. So just make sure that that information is accurate, and also make sure that any prompts that need to be filled in or any boxes that need to be checked are done. So if something doesn't apply, then you need to mark that it doesn't apply, but don't just leave it blank. So it's not a, well, I don't know, I'm just going to skip that section. Every section needs to be filled out. And of course, if your contract does not cover some issue that you need, then contact an attorney so that they can help you draft the appropriate language so that the agreement between the parties is accurately drafted. All right, now let's talk about the information that a buyer's agent needs to be collecting from their clients. Of course, their full legal names, but also their marital status. So if someone is separated or is in the process of getting a divorce or is, looking at separation, then that is going to become an issue during the closing. So If a person is wanting to take title by themselves but is married, there are things that you're going to need to discuss with the lender, the attorney, and the title company to make sure that that's possible. And if it's not possible, what steps need to be taken to make that possible. So make sure that you're obtaining copies of separation agreements if they're available or applicable. Now, all the information that we just talked about, the listing agent obtaining from the sellers, make sure you ask for that information. So ask for the easements, the restrictions, the surveys, the title policies, and then give that information to the buyer. That way they can review it and ask any questions they have before putting in an offer or before the expiration of due diligence so that they don't lose out on their earnest money. Next, you should be recommending to the buyer all of the inspections that apply to the property, whether the lender requires them or not. And one thing that we can see is often agents may become accidental inspectors for their out-of-town buyers. We strongly discourage that. Do not become the inspector for your out-of-town buyers. So in this market, when it's crazy, people will be doing FaceTime showings or they can't get down to see the property. So they may rely on you to tell them about the condition of the property. Well, get yourself out of that business. Make sure that they're getting their inspectors and they can rely on an inspector's report for those issues rather than you having to be the one trying to represent to them the condition of the property. Now, examples of inspections or different things that the buyer should obtain: termite inspection, survey, septic inspection if there's a septic system, and of course a home inspection. If the lot is vacant, have them obtain a septic improvement permit from the county to make sure that they can build a home that will accommodate enough bedrooms. So for example, if the lot will only perk for 3 bedrooms, but they have to have a 5-bedroom house, this is not going to be the lot for them, but you won't know that unless you have obtained that septic improvement permit from the county. Next, once you find a buyer, get them hooked up with a mortgage lender so that they can get pre-qualified. Make sure that the buyer can actually afford the price range of home that they want to go look at. Have them go ahead and start getting all of their documents together so that once you're under contract, getting to the clear to close is not going to be as difficult because they were prepared and they had their information together. Also, if there are going to be any credits to the buyer, you've got to get that information to the lender because the lender has to approve those credits. So sometimes you'll find that the seller may agree to some big seller credit for repairs, but due to the lender's underwriting guidelines, not all of that credit can be used. So make sure that you're not leaving that to the last minute. Get that information to the lender very early. And then that way, if you're surprised to find that the credit can't be used, alternative arrangements can be made, or you can go back to negotiate to figure out what's the best situation for buyer and seller. All right, that's all the stuff that needs to happen before the closing, well before we even get to the closing table. But what are the things that happen near in time to the closing that you need to be accounting for? So these are the things that are going to actually help the day of closing go smoothly. And first is getting advance information to the attorney's office, obviously the contract. So most offices like to have about 2 weeks to work on title, get all the loan information prepared, get everything ready so that we can actually close. So you don't want to be calling the attorney's office 3 days before you want to close and say, can you fit me in? So make sure you get that in advance. Also, provide the phone numbers and email addresses of all the parties. So it's, for example, in my office, it's our policy that if we're talking to one of the parties, we're also talking to their agent. We're not going to be leaving you out of it, but it's really tough for you to be in the middle of trying to chase down all of the information sheets. We could be sending that to you and the buyer at the same time, and you're not having to play middleman. So give the information to the attorney early on. Also, sometimes there are things that we really need to obtain from the buyer or seller that maybe you don't need that to come through you. For example, if we need the seller's social security number to obtain a payoff, we need to talk to the seller about that rather than the seller giving it to the agent and then giving it to us. It's better if we have that direct contact. So it's hard to do that if we are not provided the information. So up front, give the phone number and email address. Also, if the attorney's office provides an information sheet that needs to be filled out, it is not just for fun, it is because it is absolutely needed for closing, especially on the seller side when there is a lender to be paid off. Because that seller's information sheet, at least in my office, includes the payoff authorization. And if we can't get the payoff for the loan, we can't close. So sometimes those loan payoffs take several days depending on the lender, or up to weeks, so 7 to 10 days. So it could be 2 to 4, it could be 7 to 10 days. So if you don't provide that payoff authorization until a day before closing, you are not closing the next day. So have your clients be filling out those information sheets very promptly and providing them back to the attorney's office. It is not busy work, it is because it's actually needed information for the closing. Also, let the attorney's office know whether all the parties can attend closing. There are often times where, agents may assume, oh, well, the seller's wife has power of attorney for the seller, so we'll just have the seller's wife show up and we won't tell the closing attorney's office that seller can't come. Well, that's an issue because then all the documents have to be redrawn to account for that power of attorney. Or if your client needs a mail-away closing, tell us that in advance so we can make the arrangements. So if a party is not going to be able to be present, we need to know that sooner rather than later so that the documents can be prepared appropriately to account for the situation. So in addition to a copy of the contract, which is the first thing we need, make sure you send copies of any amendments and then also any inspections that were done, not necessarily the home inspection, but the termite inspection, and then also any invoices that need to be paid. So if a surveyor needs to be paid or an inspector needs to be paid on the closing statement, we can't make sure it's on the closing statement if we don't have a copy of the invoice. So make sure you send that to the attorney's office ahead of time. A lot of attorneys' offices will be handed copies of those invoices at closing. Yes, it can be adjusted on the closing statement. Not always quickly, though. If there's a lender involved, the lender has to approve any changes to the closing statement. So if you're waiting till you get to the closing statement to hand over those invoices, you may have just tacked on significant amount of time to your client's closing because we'll be waiting on a lender to approve any changes to that closing disclosure. And also prepare the parties for disbursement. So this is kind of the final part of making sure that the closing goes smoothly, is letting the parties know when they need to have their money into the closing attorney by and in what form, and then when the seller will get paid. So you need to make sure that your buyer knows that certified funds have to be in the attorney's trust account prior to any deed being recorded. So in North Carolina, a lot of funds have to be wired if they're over a certain amount. And if your client's bank is not in the state where the property is located, then they need to be calling that bank many days in advance to figure out the protocol for wiring. Sometimes banks require you to be in person, and if the bank is in a different state and the client's in North Carolina, it's very difficult to initiate an in-person wire. So do not be waiting until the last few days before closing to make those arrangements. Now, I know that means sometimes you're sending a wire before you have final funds, and that's okay. Just get close, and then you can bring a checkbook to closing for any minor differences. But the bulk of the funds have to be certified, so you have to make sure that those funds are in the attorney's trust account as quickly as possible. Because the longer it takes to get those funds in, the longer it will take to record. And speaking of recording, the seller does not get paid until the deed records. So sometimes seller will say, well, I'm not giving over the keys until I have my money. Well, that's not how it works. The buyer gets possession at the recording of the deed, and then the seller's funds are dispersed at the recording of the deed. So that means that the seller can provide wire instructions. So perhaps the wire will be sent to the seller's account, or they can pick up a check at the closing attorney's office. But they need to understand they're not going to be written a check at the closing table. So the deed won't be recorded till all the money's in the attorney's account. Once the deed records, buyer can get keys and seller can get their funds. Now, this can sometimes present timing issues. So if you have a seller that is buying somewhere else later in the day, please do not surprise the closing attorney with that information at closing. Because if we know that, then we can try to make accommodations to facilitate the timely transfer of funds. Some of that timing is out of our hands because it's in our bank's hands of how quickly that they transfer the funds to the next attorney's office. But if we have advance notice, then we can try to schedule that closing earlier in the day so that we have more time to get the money to the next closing for that seller. So please don't let that be a surprise for the closing attorney at the closing table to say, we have to have this dispersed today. So let us know in advance so that we can try to accommodate that as much as possible. I know that was a lot of information. In fact, this is an actual seminar that our office gives to real estate agents in our local community to try to help them do a better job for their clients, and then also so that we can help them just get more business and continue to grow and thrive. So if you like information like this, then please subscribe to the channel where we have more content to help agents try to get to the closing table more smoothly, and also to help them educate their clients on the real estate closing process. I'm Tiffany Weber, and I'll see you in the next video.